So next I have the honor to introduce my very dear colleague from the Portuguese Society of International Law, Professor Fernando Loureiro Bastos from the University of Lisbon, who is going to speak to us about a legally binding instrument on plastic pollution. Some questions and problems. We've heard yesterday about the significant achievement of the BBNJ, and now there is a new process that has started more recently for a new legally binding instrument. So although some say that we're in a multilateral ice age, treaty ice age, there are some signs where the issues are affecting the common interests of the international community. There's movement from states in addressing those issues. So, Fernando, the floor is all yours. I'm very sorry you're not in Lima with us, but we are very glad to have you from Lisbon. Please.
Thank you, Patricia. I'm really very sorry also not to be in Lima, but well, it was life. But I would like to start by thanking the Sociedad Peruana de Derecho Internacional por organizar esta conferencia. Es muy importante las temáticas que estamos a tratar y, portanto, muchas gracias por organizar y muchas gracias por la invitación a la Sociedad Portuguesa de Derecho Internacional. I'm trying to stick to the time, so I have a small PowerPoint, and I will start. So we are going to talk about the starting point of discussing a new treaty, a new global treaty, an international legally binding instrument on plastic pollution. And because we are just starting the process, I have some questions and some problems that I see for the negotiation. But first of all, it's very important to know that we really have a problem about plastic pollution. Using an article of 2017, the authors say that we estimate that 8,300 million metric tons of virgin plastics have been produced to date. And what they estimate is that by 2050, we'll have something like 12,000 million metric tons of waste, because there is only 9% of recycled plastic and 12% of plastic that is incinerated, so the rest is waste. And for that reason, more or less a year ago, we had in 2 March 2020 in Nairobi, Kenya, 175 countries participating in the United Nations Environmental Assembly adopted Resolution 512 to end plastic pollution towards an international legal binding instrument. And from that resolution, the United Nations Environmental Programme Executive Director convened an international negotiating committee. And the International Negotiation Committee had a first meeting in Uruguay from 28 November to December 2022. And it was a large meeting with 2,300 delegates from 160 countries. And in that meeting, the objective of the treaty is to protect the environment and human health from plastic pollution and ultimately end plastic pollution. The process is just starting, and most likely we are going to have 5 conferences, intergovernmental conference, second in Paris in May, June, the third in November 2023 in Canada, the fourth in April 24. I have a mistake there, sorry. And then the 5th October, November in the Republic of Korea. And the idea is to complete a draft treaty in order to be discussed and approved in mid-2025 by a diplomatic conference of plenipotentiaries. On the 9th December 2022, the executive secretary of this negotiating committee sent a notification inviting written submissions from members of the committee and from observers. And they received 239 written submissions, 55 from members and 174 from stakeholders. And the texts are available online, and it's very interesting to see how diverse the perspectives about this matter are. And what they were asking in these submissions were, first, the substantive elements. What could be the objectives of this instrument? Then, core obligations, control measures, and voluntary approach. So how to provide a comprehensive approach to addressing plastic pollution, including the marine environment, throughout the full life cycle in line with the future objectives of the instrument. Then they were asking also about implementation elements, and they were so asking about additional input, other questions like awareness raising, education and exchange of information, research, stakeholder engagement, institutional arrangement, and final provisions. So, what we are going to see most likely in the second conference is a document that is going to be prepared using all these written submissions, and the objective of this document is to have a comprehensive approach that addresses the full life cycle of plastics, how is called by the UNA Resolution 514, including identifying the objective, substantive provisions, including core obligations, control measures, and voluntary approaches, implementation measures, and means of implementation. So, we are discussing a new treaty, and I have some questions and some problems when I'm looking at it. I am not part of the negotiations, so I'm looking at it as an observer, an external observer, looking at what is available online mainly. So first, my first problem is, it will be possible to respect the deadline for drafting the text of the treaty? Because we are talking about 2 years, 2.5 years. It is possible when we compare with the BB&J negotiations that took 15 years, and we are still, the final text is still being drafted. So first question, first problem. Second one, what will be the objectives of the treaty? So, from the first intergovernmental conference, we see that it's protect the environment and human health from plastic pollution and ultimately end plastic pollution. So the problem here is how to cover the full cycle of plastics. It will be possible to have such a complex treaty that will be enough to cover from consumption to production to consumption, and to put an end to the plastic era. And then what is the meaning of a circular economy approach when we are dealing with these questions? And one problem that I think is going to be really important is how to deal with third states. Because we saw that 170 something states approved the resolution. The first conference had 160 states. So how are we going to deal with third states that are not going to be part of the negotiations and part of the treaty? Then, third question, third problem, geographical scope of the treaty. So, We heard Nellifer talking about how these questions deal much better with land territory than with the maritime spaces. And the problem is, when we are dealing with something of this kind, dealing with territories is much, much easier than dealing with maritime spaces. The problem is how to deal with obligations of states in the high seas. How are we going to address that problem? And who is responsible for the plastic pollution already existing in the sea, namely microplastics? Fourth question and problem, object of the treaty. So, what type of plastics will be included in the treaty? The questions of microplastics in the sea. When we read about this, we see that there are hundreds, thousands of products that can be included in this treaty. How are they going to be dealt by the text of the treaty? So, most likely, we'll need flexible mechanisms to amend the treaty, the text of the treaty, according to scientific and technological advances in this field. Then the fifth problem will be about domestic implementation and capacity building. The question is how to achieve a national implementation system that takes into account the particularities of different communities and different levels of economic development. For sure, we have a problem of plastic pollution, but I think it's not going to be easy to address it with just one model of solution that can fit all countries and all communities and all different levels of economic development. Sixth problem will be the relations with other international legal regimes. It is possible to create a regime that does not overlap with other existing ones. If we see some of the documentation and people are dealing with this treaty as a human rights treaty and as an environmental law treaty, we see that some of the comments are establishing relations with dozens of treaties. How is going to be possible to organize the coordination, the harmonization with all the other international legal regimes? In particular, when we are looking from a law of the sea perspective, how it's going to be possible to have a compatible regime with UNCLOS and with the new BBNJ treaty. And, for instance, I'm putting here Article 4 of the BBNJ treaty, just to see how difficult it is to harmonize treaties when we are dealing with the law of the sea. The seventh problem will be institutional arrangements. What type of institutional arrangements? One thing that is very interesting to take into account is a system similar to paragraph 4 of Article 48B's transparency of the BBNJ treaty. The representatives of states not party to this agreement, relevant global, regional, sub-regional, or sectoral bodies, indigenous people, and local communities with relevant knowledge, the scientific community, civil society, and other relevant stakeholders with an interest in matters pertaining to the Conference of the Parties may request to participate in the meetings of the Conference of the Parties. This is a very interesting model. Most likely it's a way to deal with third parties and is a way of deal with a range, a very extensive range of stakeholders. The eighth problem, it's about reservations. Is going to be possible to accept reservation to this treaty? Because we have several possible approaches to it, but even if it is a human rights treaty, it would be possible to have reservations. So, and how to deal with reservations and the main core of obligations of the treaty. And finally, it would be very interesting to see if we are going to have a specific settlement of disputes mechanism. Because we are going to deal with very, 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 very technical questions. And for that reason, it would be most likely very interesting to have something similar to what was achieved in the BBNG Treaty, Article 54 ter, where a dispute concerns a matter of a technical nature, the parties concerned may refer the dispute to an ad hoc expert panel established by them. The panel shall confer with the parties concerned and shall endeavor to resolve the dispute expeditiously without resource to binding procedures for the dispute of settlements under Article 55 of this agreement. So, we are starting the discussions. So, most likely, many of my concerns will be overcome and will be not a problem. But it is going to be very, very interesting to see a first text and how long it's going to take to achieve a final text and a treaty, an international legal binding instrument on this matter. I'm very optimistic about it because we can say that there are no one is disputing the necessity of achieving it, but a completely different thing is to have a final text to be signed and ratified. So thank you very much for your attention, and it was very good to share with you my thoughts about it.
Muito obrigada, Fernando. Thank you so much for drawing our attention to this new development and also for highlighting a number of important legal questions that certainly will be thoroughly discussed during the negotiations. And if we manage to achieve BBNJ, although it was 15 years, I'm sure we will do it also with the plastics pollution treaties.